Great. Amazing. So welcome again, Sandhya ji, Deepa ji. It's a pleasure for me to be anchoring this discussion with very experienced people like the both of you. So for all our participants, the topic again, I would repeat that today we are talking about the complaint filing, the inquiry when the respondent is a third party. It's a crucial topic. There are several complexities that people might experience when the respondent is a third party. And at such times, for HR professionals, for IC members, it's very important to know what does the law mandate, ensuring fair procedures are followed, making sure that all parties are protected. Yeah, and most importantly, it is necessary to keep the spirit of the law alive. Okay. So I'm looking forward to an insightful discussion with both of you today. And I'm hoping that all the tips and the discussion helps the participants deal with such cases very, very effectively. So I want to begin with Sandhya ji. Let me ask you, I just mentioned to get this topic started that I mentioned the term spirit of the law. So can you explain it to our participant that what does the phrase spirit of the law really mean? How would you describe it in plain and simple terms?
Okay. So I'm going to start with an example. All of us know the story of Bhauri Devi, right? Now, in 1992, when Bhauri was gang raped, the remedy available to her was to go to the police station and file a complaint, right? She went ahead and filed a complaint, etc. And you know what happened at the end. The persons got away. There was hardly any punishment given to them. And subsequently, Vishakha, which is an NGO, came up with a PIL, that is public interest litigation, and filed a complaint, filed the PIL before the Supreme Court of India, saying that this has happened with this woman. She has been raped because she was carrying out her workplace duties. She was trying to stop the child marriage. And because of it, as a consequence of it, because those people were annoyed, etc., she was gang raped. So there is no law as such which is talking about safety of a woman at a workplace. So they had appealed to the Supreme Court that you should lay down certain guidelines. Now, at that point of time, there was no law, right?
Right.
There was no law accepting the IPC wherein a woman had to go to the police and file a complaint. So there was no law as such. Now, it was very easy for the Supreme Court to say, there's no law. We can't do anything. That's a matter of the law. Whether there is any act which specifies exactly what has to be done if a woman is harassed at her workplace. But they did not do that. They looked at the spirit of the law. What is the motive for which? Now we have our constitution, right? Now the constitution guarantees certain fundamental rights. Dignity, safety, ability to practice any profession, all these things. So then they took it up and they passed the Vishakha guidelines because they were following the spirit of the law. Spirit of the law means the motive for which the act has been passed. What is the evil that they are trying to rectify? So that is the reason why they passed the Vishakha guidelines. Just 1 second, please. And so when we talk of when an IC is faced with a certain, question, they will not look at only what the act is talking about, the technicalities of the act. They will look at what is the motive behind which the act has been passed. What is the intent behind which the act has been passed? That is what is called a spirit of the law. Why was this act passed? And they will act according. If there is a conflict between the two, the letter of the law and the spirit of the law, they will go ahead with the spirit of the law, because that was the purpose for which the act was passed.
Got it. So in one sentence, if you have to explain what is really the spirit of the Posh Act?
So the spirit of the Posh Act would be to ensure that woman has a safe and a respectful working environment where she can work without being harassed. There is she has her dignity at her workplace. It's a safe workplace.
Right.
And she can practice any profession.
Yeah, great. Thank you for that. I'd move to Deepa ji and maybe pose the same question to you. If in one sentence you have to tell our participants that this is the spirit of the law, then what would that statement be?
For me is so far as Posh Act is concerned, I agree what Dr. Sandhya said is respectful work atmosphere wherever I am working, whatever type of work I am doing. But along with that, I do have to respect the people working with me, my team, whoever is there, my seniors, my peers, my juniors,
Mm.
all are working in my office. I have to respect them also. Why I'm
Mm.
telling you is just to avoid that thought of male employees that Posh Act is a weapon in the hand of women. That is what in many of my seminars
Yeah.
this has been told. So
Mm.
it's not like that. We are not on that it is a weapon in the hand. We respect all the genders. We expect our all the female workers, so whatever
Right.
working in whatever capacity and whatever workplace, we have to respect our team. It's
Right.
not that on men are coming to office to sexually harass all of us like that. They
That's
are also coming to work. So let's
absolutely.
respect that also along with, and act looks at that also. That is why there is a clear provision for action on malicious complaint. So
Absolutely.
if we look at the Posh Act spirit, it's not only respectful atmosphere or workplace to me, it is for everyone around me, and my duty also to respect them as well at the workplace.
Absolutely.
I'd
Great.
just
Thank you.
like to add one point here, Deepa.
Yes,
Many
Sandhya
times,
ji.
there are technicalities. Now, say a
Mm.
woman has to file a complaint within 90 days.
Mm.
If she has gone to 91st day, the letter of the law says you can't accept.
Yes.
But the
Right.
spirit of the law says it is for a purpose of creating a
Absolutely.
safe workplace. You can accept. So
Absolutely.
that's how it is. So the
Very nice
courts
example,
generally
Sandhya ji.
go beyond the courts generally go beyond the technicalities and
Understood.
try to understand, the situation, and they may take a decision in order to honor the spirit of the law.
Wonderful. Great example. Thank you for that. So, Deepa ji, next question is directed to you. And when we conduct as Yellow Spark and training sessions with IC members, there's one common question, that it's easy if both the complainant and respondent are from the same company. But what if the respondent is not our employees, not from our organization? And just to give an example, very recently, we were discussing this example that there's a female colleague who's gone to attend a conference, and an individual who's also attending the conference maybe pass some suggestive comments towards this female colleague. And in such a case, what options does this female colleague have? And I'm sure you must have come across many such cases. So without sharing confidential information, if you could give examples or describe how the case is handled, especially if the respondent is a person of authority, let's assume from some government institution. How
Hmm.
do you go about this?
Right. So before we go for third party respondent, first thing is let's understand which is the third party respondent. There can be different third party respondents. One
Good point.
person is my vendor or my client, with whom regularly I'm interacting. My vendor or client belongs to other organization. I belong to a organization. We have the commercial working relation. Two organizations, we are working together. That is
Right.
one scenario. Scenario is where a person who is interacting with me, I'm at my workplace, the person interacting with me is one individual, not interacting with me in his official capacity, even if indeed in that way. So I or that person is not coming from any structured office, maybe an individual
Right.
interacting with me I'm in an official capacity.
Yeah.
Other person may not be.
Hmm.
Third is there is nothing, no relation between both of us.
Hmm.
Nowhere. I am going for a training. I took along with my sister. Okay, after the training, we'll go for a shopping. My sister also come along with me, sit there for the session for an hour, and then we went out. That time, my sister doesn't have any relation with anyone wherever I am going for a training. Third can be in a different capacity, right? If first such scenario, if we take my client or my vendor or anyone where I have a
Hmm.
regular work relation,
Hmm.
basic thing is complaint should go to the respondent's IC. That is what, and as we look at the Posh Act also, so it will go to the respondent's IC. So if I am sexually harassed by my vendor's employee, I have to file the complaint to vendor's IC. Now I don't know where the vendor's IC is.
Right. Hmm.
So
Hmm.
where do I go? So I can
Hmm.
go to my IC. it's a duty of my IC to forward that complaint to vendor's IC and guide me and help me to reach up to them. Or
Got
I
it.
can file a complaint to SheBox. They will send the complaint on their own, and I will get information from them to go ahead and have my case there. That is the first scenario, right? Now, second situation is where person is an individual. Like you take an aircraft. I am a crew member and person is traveling in the aircraft. Now we have many instances of unruly passengers in the aircraft. They
Yes.
misbehave with the crew member. Now that person is an individual. What will you do? Where will you file it? Even if I file a complaint in my airline IC, what my airlines can do? Maximum. You can terminate a person under Posh Act if you look at strictly. From where you will terminate? I'm not working anywhere. I'm an individual. I'm only traveling. That is where the airlines is, they put the person on no flyer list. That this person will not get any ticket from now onwards in my airlines. That is where this no flyer concept came in. Because you can't take any other action except to go to police. Police is definitely there.
Yeah.
Comfortable going to police and then running around the court and lawyers and all that. So that is where that no flyer thing comes in. It is same with, if you look at the big hotels. I don't know whether anyone has looked at. If you look at the posh policy of like Leela or Taj hotels and all, there also they have kept the same situation. One individual coming and staying in my hotel and misbehaving with the staff of the hotel. They put that person in no customer zone. In that case, they don't allow that person later to come in any of their hotels and guide their female to file the police complaint. IC can do anything. It's not effective outcome of this.
Got it. That is if it's an individual. So that is
It's an individual. Yes. If
that's
the person
situation.
coming to structured office and I am going for an official tour, then yes, you can file the complaint in my IC. All good.
Right.
But other, if I'm individual, what will how Posh will help? It's
I
very
understand.
difficult.
So the organization doesn't have jurisdiction over this individual, and therefore there's not much that the organization can do. Especially because it's an individual, and later in the panel we are going to be focusing a little on still what are the options, and we'll invite Sandhya ji to do that. But coming back to, there was a recent judgment wherein the Supreme Court said that if the respondent is from a different company, the IC of the complainant's company can handle the complaint. Can you shed some light on this recent, just help us decode it. What was this interesting case?
That judgment is concerned, I agree with what the judgment was there. There, both the employees, both the people, their employer was same. That is Government of India.
Okay.
They may be in a different departments of Government of India, but they were governed by the same working rules. The code of conduct was same for both of them. Service rules were same for both of them. And the way the action is to be taken was same for both of them. It's not that two are in a very different, where my code of conduct is different, everything is different. It's not like that.
Okay.
So in the my interpretation to judgment is, look, if we both belong to maybe a different establishment, but governed by same service rules, same type of, then yes, I can file a complaint to my IC. But if we two are in a very different two organization governed by two different set of rules, it will not help me. I file a complaint to my IC. My IC has issued a notice to respondent. He will clear it and put it in dustbin. The person will not come up. Okay, you give the 3 notices and you proceed ex parte. You give your recommendation also. If the next employer, why the next employer is bothered about your recommendation? They will put it aside. They will not take an action. Then I have to go to court to get the other employer to take an action on that.
Yeah, got it.
They will not bother. Nobody is going to bother. My IC will give a recommendation to other organization. They are not going to look at. And ultimate result is 0. Nothing will happen. So that will not help me till we, that is what my interpretation of judgment is. If we are governed by the same service rules, or maybe a 2 different location of same office. Same office, I am posted in Bangalore, other person is posted in Mumbai, and something happens. But either of the place IC can take a call.
Got it. Got
Can
it.
I add
So,
something to this?
Why
yes,
not?
yes,
Sure.
Sandhya, please go ahead.
Unless you have something more to say. I just
No,
want to
no,
add a
sure, go
couple
ahead.
of things to this.
Hmm.
See, this particular judgment that was passed is giving an interpretation of Section 11. Now, Section 11 says that where the respondent is an employee of a company which is governed by service rules, the process, it will go by the service rules. Where the company is not governed by service rules, it will go as per provisions of the law. And third, where the person is a domestic helper, it will go to the local committee who will send it to the police. Now, the court has said that this is not saying that the respondent's IC has to take it up. This is giving 3 scenarios. If it is governed by service rules, handle it like this. If it is not governed by service rules, handle it like this. So
Got
it
it.
is explaining how it needs to be handled. And because of this judgment, a woman who faces harassment from a person from a different company can submit the complaint to her own organization, and her own organization will handle the complaint. She does not have to go to the IC of the respondent's company. And the judgment clearly lays down that in case if our IC needs some information from the respondent's employer, they can write to the person, and that employer is bound to provide that information. And this, what it will do is it will go through all of it. It will be, find out all the details, examine everything, and the report is then submitted to the employer of the respondent, who gets 60 days time to take necessary action. So this is how it is handled. Similarly, in case if it's service rules, then it is handled in a different manner. There, the committee will only be a fact-finding committee, which will find out all the details and then send it across to the employer's respondent's employer. And then it goes to the disciplinary committee and it follows the process of the service rules.
Got it. Got it. So, because we're saying service rules, and sometimes it's very complicated for the HR teams to understand. So, what exactly would you say are service rules? Like, is it applicable to all organizations?
No,
Is it
so these are
applicable
for the central
specifically,
government employees.
only
The
specifically for
government
central
employees,
government?
primarily, they are governed by service rules.
Right.
Or
Because a lot of
suppose in
times,
railways would have their service rules. Government bodies would have their service rules. So service rules, if they're governed by service rules, it goes as per that. If it is not governed by service rules, it goes as per the Posh Act.
because a lot of times there's this confusion about, is an employee contract, are employee policies, is the code of conduct of an organization also service rules? And then
Yeah. So the thing is that if you look at the definition of the term employee under the Act, it talks about somebody who's on rolls, somebody on contract, right? It could be an intern, it could be a probationer, it could be an apprentice, temporary worker, daily wage worker, ad hoc worker. All these are considered as employees. So if a contract worker is facing harassment at the workplace, that contract worker can file a complaint with the IC, and the principal's employer's IC will take it up, because this contract worker is dedicatedly working for this principal employer. So in such cases, it will be taken up by that. The contractor will be kept informed that, yes, this is a complaint that has come in, we are handling it. And that is how it goes. I have seen some organizations allowing a person from the contractor side as an observer, but there is no rule as far as statute does not expressly state that, nor does it forbid it. I have seen some companies allowing an observer from the contractor's side to remain present during the IC proceedings, just to ensure that it is happening in a fair manner.
Got it. Got it. Deepaji, again, very quickly to you, is anything on service rules? Like, again, I'll repeat my question that organizations often feel employee policies, the internal code of conduct, the appointment letter which outlines contracts, is that also understood as service rules?
Service rules is terms and conditions or do's and don'ts given to me when I'm joining a particular organization, and I have to follow that. Now, whether I like it or don't like it, if I'm joining a particular organization, the whatever have been asked is told to me. This is the office time. This is the office place. Here you have to come to do that. If I don't agree, let me move on. Service rule, as such, when we normally, as Dr. Sandhya said, we discuss it, we look at government sector. Government
Right.
sector, there are PSUs, they have their separate service rules. Central government employees have one service rules. Those are service rules governing all the central government employees across the country. There are state government offices where the state government service rules applies. That is
Got
only for government sector. Or if you look at the PSUs, they are autonomous bodies, many of the PSUs, so they have their own service rules. That is the service rules. So come to the private organization. Yes, my employment contract, my code of conduct, my policies within the organization, all are cumulative. Together we can say service rules.
Got it,
Service
ma'am.
rules is, if we look at it, basically the terms and conditions which are governing my job at a particular place.
Got it. Got it. That's helpful. It's
Follow that if
basically
my
just
code of
terms and
conduct.
conditions.
First thing is that which is telling me this you have to do in the office, this you don't have to do.
Got it. Got it. Got it.
You name it, whatever HR policy, code of conduct, service rule, you name it, whatever the ultimate thing is, something which is governing me at a workplace.
Got it, ma'am. Got it. So coming back to our third party respondent, Sandhya ji, what if the person is an unknown third party? Where does that complaint go?
Okay, so in such cases, the woman can go to the police and file a complaint. So primarily,
So,
a
ma'am,
woman who
but
faces, I'll
on on the police, I have this thing. It's my personally, I feel very confused and intimidated about going to the police and filing a complaint. We've heard complainants, HR even feeling the same way. Is police really approachable? Can they refuse to accept my complaint?
Okay, so I'm going to tell you how it can be done. Number one is a woman who faces sexual harassment at her workplace has two options available to her. One, she files a complaint with the internal committee under the Posh Act. Second, she can also go to the police and file a complaint. So she has a civil remedy available to her under the Posh Act. She also has a criminal remedy available to her under the Bharatiya Nyaya Sanhita. Now, having said that, I'm going to tell you what is an FIR, what can she do, talk about all that, and what can she do in case if the police refuses to take the FIR. There have been times where they make the person sit for hours together to the extent the person gets fed up and says, forget it, I don't want to file a complaint. So I'm going to cover
Exactly,
all
ma'am.
those aspects. So just give me a moment, please.
Sure.
I have created something which I think I can share with all of you. Right, so I'm just going to start from the beginning. So just give me a second, please. I'm just going to move this out. Let me just go and start from the beginning. So let's talk about what is an FIR and what is a zero FIR and what is an EFIR, right? So FIR is, do you want me to close this window, Willis? I can just move it aside. Okay, here. Okay, so what is an FIR? Basically, it is the first information that you go and give to the police on the occurrence of a cognizable offense. Now, what is a cognizable offense? I'm going to talk to you about that. So primarily for FIR stands for First Information Report. So it is a document which is prepared by the police. When you go to the police and you tell them about a complaint which is a often cognizable offense, the police will document it in a specific format. That particular document is called as a First Information Report. Now I use the words cognizable and non-cognizable. Now, cognizable offenses are those which are serious where the police can arrest without a warrant.
Okay.
They do not need anybody's permission. They can straight away arrest the person. They don't need any court's permission for that. And these are generally serious offenses. Now, non-cognizable offenses are those where the police cannot arrest without getting the court's permission. Incidentally, all the sections which are, relating to sexual harassment are cognizable offenses. So the woman can go to the police and file a complaint, and the police has the authority to arrest. They don't need the court's permission, right? Now, what is a zero FIR? Now, many a times you see, you don't know this, you've seen something happening. You don't know whether this is coming in this particular police station or the other police station. So you can file what you call as a zero FIR. It can be filed at any police station where regardless of where the crime has occurred. So the officer who will take the details of the incident that has happened will assign a number 0. 0 means it is a 0 FIR. Means the jurisdiction is not, looked at. It's basically the complaint is looked at. So primarily when Sushant Singh Rajput, when he was, killed, his parents were in Patna, they went and filed a 0 FIR. So who can file a 0 FIR? It's the victim who is, directly affected, or the informant, somebody who knows about it, can file the 0 FIR. Now, how do you file it? You approach the police will document all of it, conduct a preliminary inquiry, and if they feel, yes, there is an offense, they will register the 0 FIR. And then after that, they will forward the 0 FIR to the police station, which has the jurisdiction. When
Got it.
that police station receives the 0 FIR, they know it is for their particular police station. They will re-register it, and that will be a regular FIR with a proper FIR number. And once that FIR is registered, it is assigned to an investigating officer who will then investigate the matter, and then subsequently, after all the investigation is done, go ahead and file a charge sheet. Now, why is it important? Why is it important for all of you to know about the 0 FIR? See, many a times, when you go to a police station, they'll say, no, this one doesn't have jurisdiction. That one has, you keep running between pillar to post. You don't
Yes.
want that. So that's why it helps to speed up filing. You can file a 0 FIR at any police station. They will go ahead and, conduct a primary inquiry, then, register it and forward it to the correct police station. Now, what happens if the 0 FIR is refused? Now, I had a case which which was my personal case, where we had filed an FIR, the police were not taking any action. So then the next step is to send a complaint to the superintendent of police. Right? Now the superintendent will look into the complaint. If they feel, yes, this is a cognizable offense, action has to be taken, it will direct an investigating officer to look into it.
Got
Now,
it.
in my case, the superintendent did nothing. Then I had to go to the magistrate's court and file an application. So then once the magistrate looks into it and sees, yes, this is a cognizable offense, then the magistrate gave instructions to the police officer to, conduct an inquiry, file a proper FIR, and go ahead and conduct an inquiry. So if a police refuses to file the FIR, one option is to go to the send a complaint to the superintendent. If still that doesn't work, approach the magistrate, and the magistrate will look into the matter and feel if it's a cognizable offense, will direct the police to file an FIR. Now, having said that, there is also a provision, what you call as an e-FIR, where you can do it digitally, right? So it allows citizens to file the complaints online, right? So it becomes easier for us. Now, who can file an e-FIR? The victim, somebody who's seen it, somebody who knows about it, they can file it, but you can file it only for cognizable offenses, which are serious offenses. Now, how do you file it? You log into the e-FIR portal, submit all your details, and whatever has happened, you submit all that. The investigating officer will review all of it. Then within 3 days of you having submitted, you have to go to the police station and sign the FIR. The sign over there that, yes, you have filed this. Now, you would be happy to know, for women, statement needs to be recorded by a woman police officer.
Right.
Right. And so, particularly many times a woman doesn't want to share the details. She's uncomfortable sharing it in front of a male. So a woman police officer will take the complaint. In case the person is disabled, the police will go to a location of their choice, and there could be an interpreter or an educator who will, explain whatever is being said, and the entire process is videographed. The person who's filed a complaint will get a copy of the FIR free of charge. Now it goes to the inspector, who will check, and he will allocate it to an investigating officer, who will then conduct an investigation and then go ahead and file the charge sheet. Now, in case if the e-FIR is not registered, same thing, go to the superintendent of police and the SP will order the registration and investigation. Now, the police are duty bound. If they knowingly fail to register or investigate a cognizable offense, that police officer can face up from 6 months to 2 years of imprisonment and a fine, right? So the difference between the three, one is a regular FIR, one is a 0 FIR, and one is a e-FIR. So these are the 3 types of FIRs that are available. Your rights are protected. So if ever you face a problem that the police officer is not cooperating or something, say, okay, fine. If you don't, I know what are the steps ahead. I will reach out
Got
to
it.
the superintendent. I will reach out to the court.
Magistrate.
So this is what is all about EFIR. So I hope
Wow.
after this, people will not feel
Amazing.
scared or nervous to go to the police and file a complaint. Most of the times,
Amazing.
the police are cooperative. To tell you something frankly, there are times where the police have been managed, wherein they put sections which are which is diluting the crime. So if the crime is serious, they may put sections which are not that serious. So that was something also that I have seen. So it's very important for you to know what is the law, and that if you go to the police, if the person is not cooperating, you have a remedy availability.
No, wonderful, Sandhya ji. Thank you for this detailed overview. And I know that because of the paucity of time, we can't spend a lot of time on it, but you still, in a very crisp way, gave us all this information. And my biggest takeaway is about zero FIR and the EFIR. I didn't know that these two existed. And I think most common people don't know it. And um, several times our clients who have a fully virtual organization across India, they keep asking us this question: how do I direct my employee to the police station? Because I don't know the nearest police station. Everybody works from their home. But this information about zero FIR or EFIR is extremely information, very, very relevant and critical information. If you're all right, please share this with us. We're going to share resources with all our participants. We would be eager to circulate it to them as well. So moving forward and coming to you, Deepaji, therefore, that once in a particular case what we were handling, the complainant suddenly decided that now I want to file a police complaint during the inquiry. Okay. And she said, I'm going to go and file a police complaint. And then after a few days, she said, no, now I don't want to file a police complaint. So sometimes when complainants do this, it really throws the IC off the mark. And it was quite confusing for the IC that what do we do if the police gets involved? Will there be a parallel inquiry? So in your experience, what guidance or do's and don'ts would you suggest to the IC, and what happens when police also gets involved?
Now, one thing is, please understand that police action is different, Posh action is different. Posh Act is a civil law, and complaint will be handled by the internal committee. When I go to police, my complaint is registered under BNS, Bharatiya Nyaya Sanhita, criminal action, where police will investigate and matter will go to court. Both are slightly different. Posh IC, we go by preponderance of probability. That is in civil law. In criminal, it is beyond reasonable doubt. So the whole process of investigation, we do inquiry. Internal committee does inquiry. Police does investigation. And there is a difference between inquiry and investigation. First of all, it is my call. I am sexually harassed. I can go to IC. I can go to police. I can go at both the places at whatever stage. That is not relevant. Because for IC, I still have 3 months time. But going to police, I have 3 years time limit. I still have more time. And after whole inquiry also, I can go to police. I still have that time, right? Let her file a complaint whenever she wants. Let the inquiry be in process. Let the complaint be there, police complaint. Both the process are absolutely different, not dependent on each other. You do your work, let them do their work. Only thing can be the police can come to office and police can come ask for your CCTV. Police can take the statement of 4 employees around wherever the incident happened, whatever. Their organization have to cooperate with the police. That you cannot say, look, IC inquiry is going on, so we will not tell you anything. We cannot say. Because police have authority, they can come and they will talk. Police may ask the IC, look, whatever is happening, please share it. You can tell them, look, because of confidentiality, especially at this stage when the inquiry is on, we are not supposed to share anything. After the inquiry, if required, you can get the copy of inquiry report, but not during the process of the inquiry. You do your work. There are cases where in departmental inquiry, means before IC, person was found guilty. And in a criminal which are FIR registered, person was not found guilty. By the court, person was acquitted. For the same incident. There are cases where both authorities have taken a different decision. Possible, because here we go by the preponderance of probability, and there it's beyond reasonable doubt.
Got it.
Level of evidence, process, everything is far different in both.
Right.
Let's not club it each other. IC should not bother about if police is doing their inquiry. Let them do. You do your work. Don't get perturbed or don't get pressurized with that. It's my call. Let me do whatever I want. You should not worry
Right.
about it. You do your work. What in terms of Posh?
Right. Very interesting over there that in the same situation also, the IC and the police can come up with different outcomes.
Yes,
And because they're following different processes and the principle
exactly.
on the basis of which they are declaring that outcome are very, very different. And both can be right.
Both
Yeah,
can be
so
can be
very
right, depending
interesting.
on yes. Because both decisions are coming, there is a reasoned order. Principles of natural justice are followed at both the places.
Right.
There are reasoned order even by the court. Still, they can come out with different decisions. Possible.
Absolutely. Great. Thank
I
you
want to
for that.
elaborate a little on what Deepa has said. I'd
Yes,
like
ma'am.
to elaborate when she talked about preponderance of probabilities and beyond reasonable doubt.
Beyond reasonable doubt.
I just want to elaborate a little. So this is primarily talking about the burden of proof,
That's right.
right? Now, in a matter which is before the IC, it's a civil remedy. The burden of proof is preponderance of probabilities. That's exactly what she said, which means that IC should come to a decision that most likely this incident has happened. In a complaint, so which means, and they do not need to follow the strict rules of evidence and all, whatever is there before them, they can look at it. And if they feel most probably this has happened, they can say the person is guilty. Because the nature of the offense is such, many a times it may happen behind closed doors. There are no witnesses, right? So that's the reason why the Posh Act gives the standard of proof is preponderance of probabilities. Then, as she mentioned, beyond reasonable doubt. So in a criminal complaint, the standard of proof is extremely strict. So if the prosecution says A has murdered B, the prosecution has to prove that only A could have murdered B and nobody but A could have murdered B. And
Beyond reasonable doubt. That's
if
what.
that strict standard is not met, the court will acquit the person. So you will see, as she mentioned, you will see at times the IC will say this person is guilty, but the criminal court says this person is not guilty because of the lack of adequate evidence to meet that particular standard.
Got it. Thank you for explaining it in simple words as well. So I know that there are some questions in chat and our participants would also want to ask questions, but I have one question before we open it to all of them. So this principles of natural justice, again, both of you mentioned it very, very briefly. So there's often this feeling amongst complainants that if it's a third party, my organization is not going to pay interest to this complaint. So where will I go? And the respondent may feel that I am a third party, so this organization is not going to be fair to me. So how does the IC ensure principles of natural justice, or how should they do it? Because it's very difficult. It's not easy, and any one of you can answer, and I'd want to hear both your views on this.
You want to go ahead, Deepa? Go ahead.
Okay. So basically, principle of natural justice is twofold. Third one is nowadays with few judgments, courts have brought in the third principle also. First is I cannot be judge of my own case. So that is the very basic thing. If any of my close person
Right.
or my close team member or me is a part of the incident, I should be away from the committee. So I should be replaced. Other is no one should be punished without giving an opportunity of hearing. So that is more crucial when we do the inquiry.
Right.
What happens sometimes a party comes and says, Madam, I am ready to give you the call record, but please don't share it with the other party. That is not allowed.
Correct.
So very clear thing is everything which is shared in front of the or in on the table of IC must be shared with both the parties
Right.
without fail. You can't, the IC cannot take a call on any decision or anything, any evidence, any CCTV footage without it being shared with the parties.
Cannot be redacted. You cannot
No,
say
you
this
cannot go for something
information.
anonymous, and that is what
Yes.
happened in the Standard Chartered Bank. Few anonymous witnesses were called, and Standard Chartered IC have taken a call, and they didn't even give the name of witness to the respondent and just shared the one questionnaire that this is the questionnaire, you give your answer. Now that IC decision was challenged in the court, and court said nothing doing. You have not followed the principle of natural justice. So
Right.
that will not work. So one thing, let IC should understand. We all are part of IC in different manner. Whatever is there in front of me on which I am relying my decision, my final outcome must be in the knowledge of both the parties.
With the parties.
So
Right.
there we get confused with confidentiality and transparency. We say confidentiality. So we cannot share. Agreed. Confidentiality means you should not share it with the outside person.
Correct.
Within the IC forum, IC members, complainant and respondent are equally entitled to know everything which is there. Between complainant, respondent and IC member, there should be transparency. Confidentiality, agreed, should be maintained from outside people, not among each other. Now, one IC member says, presiding officer says, I will do this, and external member says, I will do this, and we are maintaining confidentiality. That will not work. So,
Correct.
difference between confidentiality and transparency. Within team, transparency should be there. Confidential, yes, one thing. That we have to take care. So, if we follow that principle, let it be third party. Your job is call that person, inform that person, this is what is happening. Should be very clearly on paper.
Got it, ma'am.
And the third principle, which nowadays with few judgments courts have brought in, that is everything, every decision taken by the authorities or in case of Posh by the IC should be reasoned one. It's that I like your face, so I gave a decision in your favor. That will not work. So whatever decision I am taking, whether I am coming to the conclusion that A is guilty or B is not guilty, whatever it is, should be with the reason. How
Yes.
I came to this conclusion, what evidence I relied upon, how it is not like that I like this person, I have a regular relation with this person, overall image of this person is very good in the office, that is why it is good. My personal knowledge information is not relevant when I'm taking a call as a IC member.
Right.
Everything should be reasoned one.
Document it. Document the reasoning,
clear
document
reason
the
why
logic,
I came,
the reasoning,
why I came
the
to this
analysis.
conclusion.
Absolutely.
Yes.
Absolutely.
These are the principles of natural justice. For third party also, when third party is coming, we have to call them. We have to give them everything in writing. Don't go by, I called the person and person didn't came. This call wall will not help us. So let everything be on paper clearly. Inform everything. Let the witnesses be brought in front of both the parties. Let them get an opportunity of cross-examining the witnesses, cross-examining each other. Because all these are part of natural justice.
Right.
And must be followed.
Must be followed. Thank you. Thank you for the clarity. Sandhya ji, I'm coming to you also with the same question, and I saw one pop-up question that witnesses sometimes request anonymity. But that's absolutely.
I'll explain it. Don't worry. So there is a statement in law. Justice must not only be done, but must be seen to be done.
Correct.
Right? Having said that, what are principles of natural justice? When any judicial body or a quasi-judicial body or an administrative body takes a decision which is adverse to the person concerned, they have to follow certain legal principles. Sometimes the principles are laid down in the act, sometimes they are not laid down. Whether it is laid down or not, organizations still have to follow these principles. Now, there are two principles of natural justice. The first one is nemo judex in causa sua, meaning rule against bias. The IC should not be comprised of people who are biased, right? Or partial. So that is one. So, for example, if a complainant or the respondent is part of somebody's team, that person cannot be a part of the inquiry because there is a strong likelihood of bias. That is one. The second principle is rule of fair hearing, audi alterum partem. Audi means audio. So before you take a decision against somebody, you have to give that person an opportunity to be heard. So, adding to what Deepa mentioned, that whatever evidence is placed before the IC has to be shared with both the parties, because so that they have an opportunity to cross-examine or counter, because that is the material on the basis of which you will take a decision. So if it is going to, it is possible it could be adverse to any of the parties. So both the parties get an opportunity to cross-examine. Sometimes they may send the questions to the IC. IC will do the cross-examination. So this is how it is followed. As far as the rule against bias, when the notices are sent out to each of the parties, we mentioned that these are the people in the IC who will conduct an inquiry. If you have an objection to the presence of any of them on the grounds of partiality or bias, please let the IC know by so and so date. Your objection will be considered if found valid. So
Got it.
that otherwise what will happen is halfway through the inquiry, one person will get up and say, hey, listen, but this one is a team member. I can't allow this. So this
Yeah.
is how it is taken care of.
Got it, ma'am. So when it's a third party respondent, the respondent may feel that this is the complainant's IC, so that they are going to be biased towards the complainant. So I am not comfortable with this IC looking at the case. And I think that's where the law says that the respondent's IC should look into the case. And I think you mentioned earlier also that the complainant's IC people can be there as observers.
No, I'm sorry, I will have to correct you.
Yeah.
The complainant's IC will handle the complaint, and because you are sharing everything, everything is properly documented, procedural, each and every step is followed. There is complete transparency. So you are not giving the respondent an opportunity to raise the objection that there is bias.
Got it. That is the aim, and we all
So
aim for that.
documentation is very, very crucial. And if the documentation is followed properly, all the steps are followed properly, then you don't have a problem. The person can't raise an excuse. Everything was shared.
Got it. Got it. Fair enough. So I want to open the floor to questions from the participants before we do our closing statements. So Aparna, Anumita, any questions that go ahead?
Yes, we do have. Okay, Aparna, you go ahead. Yeah.
Okay, cool. So there are two questions actually that are very, very interesting, and I'm going to start with the first one, which is that what should we do in case the ICC committee decision or the police decision? So if the decisions are different, what do we do? Do both the decisions, do they get applicable? Like if someone's lost it, like especially when it's contradictory, like at one end you're saying that okay, IC found say the respondent to be guilty, and therefore maybe there was a punitive action that was taken. On the other hand, the police said, they didn't have enough proof. So, it's difficult. Then what really happens in such a case?
You want to go ahead?
Any
answer?
Deepa ji?
Yeah, maybe Deepa.
Okay. So the thing is that IC is not bound by the police decision. If the IC has found the person guilty, they can go ahead and take the necessary action, because very simple, the standard of proofs are different. Right? In a criminal complaint, the standard of proof is beyond reasonable doubt. So just because the police have found him, do not have enough evidence, or the court has acquitted him, it doesn't mean that you have to reinstate the person in your organization. So you are not bound by that.
Got it.
All right, great. Maybe the next question, like Deepaji can help us. It's a very unique one. So the question is, if an ICC member witnesses an incident happening, is it positive for the IC proceedings or negative? So Deepa, maybe you can share.
First important thing is, if IC member is witness, better be away from the IC.
Yes.
That is the first thing. Then that person is a witness. No positive, no negative, person is a witness, will come in front of IC, give the statement. It's for the IC to take a call. Most important thing is, if you have witnessed some incident, and all probability you are being called there as a witness, better be away from the committee. Better recuse yourself, let you be replaced, at least for that particular case, should not be part of the committee. Give your statement as a witness, and let the IC take a call. No positive, no negative. because IC is a group of people. It's not one person taking a decision.
Correct.
Let
Correct.
everyone examine it about your statement and take a call.
So Deepa used a very interesting word, recuse themselves from the inquiry, right? So if a person, IC member is a witness, that person cannot be a part of the inquiring committee, right? They have to step away. Recuse means step away. So they will be called as a witness by the IC and he will testify exactly what he has seen. So she used a very interesting word, recuse. That's the term that is used if a person has to step away.
That is what the principle of natural justice says.
Correct.
You should not be interested party in whole thing.
The point
So
number
you
one
cannot be
that you
judge
were
in
saying.
your own
Yes.
case. So that is where you have to better be away from the IC.
Got it, ma'am. Nice. Great. Anumita, do you have any different questions that you've picked from the chat? Yeah, I think she has some trouble with her internet.
Possibly
No worries.
internet, yeah.
But this has been a very, very insightful discussion. Thank you, both of you, Deepaji, Sandhya-ji, for so selflessly sharing all your experience and cases and knowledge. Any parting thoughts for our participants? Any suggestions? Any words of wisdom? Any advice that you would want to give all of them before we close the panel?
So there is a very interesting statement. Law is a jealous mistress.
Okay, wow, that is interesting.
Right?
Okay.
It's a jealous mistress, means when you are in the field of law, it keeps you away from your family, keeps you away from everything, and keeps you to it. That, so you have to study. So, and it is like an ocean. I have been into it since 2017. I still feel there's so much I don't know. There's every day there is a new learning. So take it up. Ultimately, you will be IC members. Whatever decision you take is going to impact somebody's life, right? You cannot be casual about it. It's going to impact somebody's life, career, everything. So take it seriously. You don't need to rush through it. You have to do a proper due diligence, even if it is time consuming, painful, but you have to do it. So
Absolutely.
study the subject well.
Yeah, I like what you said.
There are no shortcuts.
Yes, and I like what you said. It's a matter of somebody's life.
Correct.
So you have to be extremely careful about it. Deepaji?
I agree what she said is you have to be careful because it's a matter of life of someone. It's not someone, a family also behind.
Correct.
So if I'm out from the job because of sexual harassment, at least I'm not going to get a job anywhere in India, at least for sure. So my family is also there to suffer behind. So I have to be very careful. Being IC, I have some responsibility on my head. I have to be very careful, very, very careful. One thing is, please understand, we are not sitting in IC to help the women only. We have to look into, in the given incident, sexual harassment happened or not happened. So be fair. Don't sit with prejudiced mind in the committee that I am in the committee and this is a committee under Posh, so I have to support the women. No, please don't do that. Try to sit neutrally. I know psychologist says that as per psychology, this person cannot be neutral. Any person cannot be neutral, but at least try to be neutral. Don't sit with that thought that I am here to help or to support the women only. I have to look,
Right.
that is where the principle of natural justice is important, that I have to listen to the other party as well before taking a final call. So be careful on that thought. Don't sit in the committee meeting with the prejudiced mind. Nahi, I'm here only to help the women.
Just one last point, which is extremely important, which I think I should mention. Do not be nasty or aggressive to the respondent. There have been cases where I have seen the presiding officer, you have to answer us, that kind of a thing. So you cannot do that because each person is going through their own mental trauma. Even the respondent is going through mental
Is also.
We've
Very
had
correct.
respondents who have come and cried before us. There was a case which was reported on the 2nd of September 2022 where the person said humiliated in meeting. He went home and committed suicide.
Yes, very decent.
So very important point, do not get aggressive, be polite, hear the person out. They should not feel that there is already a bias. We are here to hear you out. We will, when the person comes, explain what is going to be the process, that this is how we will be handling. We will hear you. We will hear the witnesses. We will share everything with you. And if you have questions, you can ask questions. So you have to explain the process, be very fair. Let your pen do the talking at the end. But no, there is no reason to humiliate or, get aggressive against any of the witnesses or respondents.
No, wonderful. Thank you. We are ending at on a very powerful note. I think that bringing justice, balance, neutrality, being fair to, it's not about one gender. It's about people's life, and it's about just identifying whether the incident happened or not. And it's about, in some way having compassion for the two people who've come forward. It's difficult for both the parties. So thank you for your words of wisdom. Thank you for your guidance, all your information. Anumita has raised her hand. We will
Yes.
bring her in for a moment before we close the panel. Yes, Anumita.
Am I audible? Am I audible now?
Yes.
Okay. So just last, if will take a picture with everyone. So maybe if you all can switch on your camera. Yeah.
Yes, and you'll have to remove the spotlights.
Spotlight, yeah. So then everybody.
Oh, yeah.
Wow, wonderful.
You are on the spotlight now. Wait. I don't know. Aparna, are you able to
Anumita, you'll have to take the screenshot, please.
Oh, this one. Yeah. Okay, yeah, I will take it. One more. Yeah, thank you, everyone.
Great.
Thanks.
Thank you so much, Sandhya ji. Thank you, Deepa ji. It has been wonderful. And all the information nuggets, I mean, I have gained so much from this. I'm sure the participants have too. Thank you once again.
Thank you very much.
Yeah, thank you, Sandhya. Thank you, Deepa.
Thank you. Thank you, everyone. Ma'am, the same session has to be tomorrow, or this is something different has to be done?
No, so we are continuing the session. The panel ends here.